displays the 1928 flag are or ought to be constitutionally protected. And on that basis, they seek declaratory relief. In other words, there is no flag waiver before this court. There is no allegation from the Mandela Foundation that AfriForum waived any flags. The reason why AfriForum has been cited is because they take a different view on the nature of the law. In other words, AfriForum takes the view that as much as the 1928 flag is offensive, and it asks all of its members not to display it, and to the extent that if any of them arrive at an AfriForum rally with such a flag, they're asked to put it away. The reason why AfriForum is here is the constitutional right to freedom of expression is an important right, and it requires elucidation in this matter. In fact, none of my learned friends have spent much time at all talking about the right to freedom of expression, and I will spend a great deal of time talking about the nature of that right and the jurisprudence that has been developed by the Constitutional Court and various other courts on the importance of that right. Now, the nature of the declarator, my learned friend has said he does not seek a ban. Now, the relief that they seek would be to declare all gratuitous displays as hate speech, harassment, and discrimination, which would then create this difficulty that anyone in such a manner would be open to the penalties that are envisioned in Papuda in Section 21, which include referrals to prosecution, to civil sanctions in the form of fines. In other words, that is exactly what is implied by a ban. In other words, there will be a consequence for waiving the object. In other words, to say that one could do so freely would imply that there was no ban. As soon as there becomes a sanction, then it amounts to a ban. Now, what they understand to be a gratuitous display is that if it does not serve any genuine journalistic, academic, or artistic purpose in the public interest. And the Mandela Foundation goes so as far as to include private displays of the old flag at home, at the dinner table, and around the braai. This is specifically mentioned in their papers. Now, such a ban is of a wide-reaching nature. The relief sought by the Human Rights Commission is contingent upon a finding that the term words in Papuda must bear its ordinary meaning. In other words, that it refers to words only and not to symbols and flags. And on the basis that that is not what's found, that then they would seek a declaration that Papuda is unconstitutional and that it be referred to Parliament. Now, as I've said, AfriForum is a reluctant respondent in this matter. It is a civil rights organization that is committed to upholding the right to freedom of expression while taking active steps to combat genuine hate speech. AfriForum acknowledges that the flag has this capacity to be offensive and to cause emotional distress. It has no particular love for the flag. So why are they here? Well, the line cited by Evelyn Beatrice Hall, which refers to Voltaire's sentiment, is that I wholly disapprove of what you say and will defend to the death your right to say it. In other words, free speech matters as a principle. AfriForum is not here to defend the flag, they are here to defend the right of free speech. There is another way, there's another reason, which is very eloquently expressed in a quite famous poem written by the German Lutheran pastor Martin Niemöller. He said, "First they came for the socialists and I did not speak out because I was not a socialist. Then they came for the trade unionists and I did not speak out because I was not a trade unionist. Then they came for the Jews and I did not speak out because I was not a Jew. Then they came for me and there was no one left to speak for me." Now, we will go into some detail to explain the difficulty with banning this flag is that it creates a precedent which could have devastating effects for free speech and for the display of a numerous number of flags. And I will go into some detail to explain why the slippery slope is inevitable and that the idea that it could be hyphened off to this particular flag does not follow. Now, my Lord, I will be utilizing my heads of argument as a roadmap, And in those heads of argument, I identified 12 issues. The first 4 are of a procedural nature and would dispose of both applicants' cases on that basis. The remaining issues relate to the substance of the Foundation's claim that gratuitous displays of the flag constitute hate speech, unfair discrimination, and harassment. The first question is whether the Equality Court has the power to grant the relief sought by the Foundation. Second, whether the Equality Court has the power to declare that Section 10 of Papuda is unconstitutional. Third, whether the matter is ripe for hearing. Fourth, whether the term words in Section 10 of Papuda can be interpreted to include the 1928 flag. And if the term words cannot be interpreted to include the 1928 flag, whether this makes the section unconstitutional. Next, is it a breach of international law for using only the term words? Seventh, the requirements around hate speech. In other words, is it conjunctive or disjunctive? Then, once those principles have been established, it must be determined whether the flag would constitute hate speech, harassment, or unfair discrimination. What the precedent effect would be of declaring the flag to constitute those things. And quite importantly, whether displays of the 1928 flag can be curbed without recourse to the law. There's been an assumption that this is the only manner in which one can show disdain for particular kinds of behavior, that it must be done through the strong arm of the law. And it'll be argued that there are other better mechanisms. So let us start with the powers of the Equality Court. Now, Section 21 of Papuda sets out the powers and functions of the Equality Court as follows. It says, the court before which proceedings are instituted in terms of or under the Act must hold an inquiry in the prescribed manner and determine whether unfair discrimination, hate speech, or harassment, as the case may be, has taken place as alleged. In other words, it refers to instances where an event has occurred. And after that, the court then is empowered to make an order which would include a declaratory order and all of the other kinds of relief that are set out in the Act. But in other words, the court's power is limited to a situation where the event has taken place as opposed to the prospect of these events taking place in the future. Therefore, on this basis alone, the court does not have the power to grant the relief sought by the Foundation in its papers. Now, this might explain why there was this last-minute bad faith attempt to change the relief sought by the Foundation. My learned friend's last words were that the declaratory relief sought relates to flags waved at the Black Monday protests. At no point in their papers is this relief sought. And it may very well be because they realize that they would have no case if they did not pick a specific incident, which they did not. Next, with regards to the relief sought by the Human Rights Commission, which would be to declare portions of Papuda unconstitutional, the Equality Act is a creature of statute, deriving its powers from the Act as its empowering statute, and it exists separately and distinct from the High Court. In the matter of Manong and Associates, the Supreme Court of Appeal held the following. While it is so that Section 16(1) of the Equality Act provides that each High Court is an equality court for its area of jurisdiction, that provision does not, however, mean that the Equality Court is a High Court in any sense, and specifically in the sense that it enjoys the original jurisdiction that a court has. The High Courts are the courts referred to in Section 116C of the Constitution, and the Equality Court is a court envisioned in E of that section, a court established or recognized in terms of an Act of Parliament, including any court or a status similar to that of the High Court or the Magistrates' Court. It is therefore statutorily created court, and it follows that its powers are to be found and are confined by those conferred by the statute creating it. Now, in the matter of Kwalani, Judge van Oosten of this court was faced with a question as to how to deal with two matters dealing with the Kwalani case and to consolidate them. There was a challenge launched in the High Court to argue that Papuda itself was unconstitutional, and there was the Equality Court case. And after the Human Rights Commission, being the complainant, initiated proceedings in the Equality Court, the applicant challenged the constitutionality of Papuda in the High Court. Van Oosten consolidated the two proceedings with the understanding that the judge hearing the matter in due course would do so as an equality court judge and as a high court judge because the two proceedings originated from two different courts. Presumably this distinction was drawn to highlight that a judge only sitting as an equality court judge is limited by the powers granted that judge in terms of Section 21 of APUDA, which do not include the powers to make findings of constitutional invalidity. In the present matter, the constitutional challenge raised by the Human Rights Commission does not originate from an application to the High Court, since it was only raised in these equality court proceedings. Therefore, your Lordship is bound by the statute of APUDA and does not have the power to make the finding of constitutional invalidity which is sought by the Human Rights Commission. And accordingly, on that basis, its particular relief should be dismissed. Now, my Lord, if I refer your Lordship to the specific passage in that judgment at page 130 of the first applicant's bundle, it's the matter of Quilani. It's cited as Quilani versus Minister of Justice and Constitutional Development and others, the 2015 judgment. The first applicant's bundle, not the Josie Pride bundle of authorities. That judgment starts at page 129. The relevant passage is paragraph 5 of 130. The judge, for instance, says the following. The Equality Court established in terms of Section 16 of the Equality Act has been described as a special animal that could in modern language also be described as a special purpose vehicle. It is well established, it is now well settled that the Equality Court is a creature of statute, deriving its powers from the empowering statute, the Equality Act, and that it exists separately and distinct from the High Court. In the present scenario, the Equality Court has the exclusive jurisdiction in respect of the relief sought in the proceedings before it, whereas the constitutional charge can be adjudicated only by the High Court. And in the normal course, the proceedings would have continued as parallel proceedings before two distinct courts. So, my Lord, the argument is that that relief sought by the Human Rights Commission cannot be granted because this court has no such power. Next, the question is the matter ripe for hearing? And I'll refer your Lordship to two judgments. The first, the matter of Geldenhuis, decided by the Appellate Division in 1918. There's a long history of this principle being in place. No doubt there is something to be said in favour of sanctioning the issue of declaratory orders, even where there has been no infringement of rights. But on the other hand, it would be very difficult to define the limits within which that jurisdiction should be confined, and its unregulated exercise would lead to great uncertainty of practice. After all, courts of law exist for the settlement of concrete controversies and actual infringements of rights, not to pronounce upon abstract questions or to advise upon differing contentions, however important. And I think we shall do well to adhere to the principle laid down by a long line of South African decisions, namely that a declaratory order cannot be claimed merely because the rights of the claimant have been disputed, but that such a claim must be founded upon an actual infringement. And then the Constitutional Court in JT Publishing echoes this principle. A declaratory order is a discretionary remedy in the sense that the claim lodged by an interested party for such an order does not in itself oblige the court handling the matter to respond to the question which it poses, even when that looks like it's being capable of a ready answer. A corollary is the judicial policy governing the discretion thus vested in the courts, a well-established and uniformly observed policy, which directs them not to exercise it in favour of deciding points that are merely abstract, academic, or hypothetical ones. I see no reason why this new Court of Owls should not adhere in turn to a rule that sounds so sensible. And in Ferreira versus Levine, the essential flaw in the applicant's case is one of timing, or as the Americans and occasionally the Canadians call it, ripeness. The term has a particular connotation in the constitutional jurisprudence of those countries, which may not be analysed now. Suffice it to say that the doctrine of ripeness serves the useful purpose of highlighting that the business of a court is generally retrospective. It deals with situations or problems that have already ripened or crystallized, and not with prospective or hypothetical ones. Although, as Professor Sharp points out and our Constitution acknowledges, the criteria for hearing a constitutional case are more generous than for ordinary suits. Even cases for relief on constitutional grounds are not decided in the air. The Foundation seeks to declare events that have not yet taken place to be infringements of APUDA. This relief is at odds with the approach taken by our courts not to decide on issues that are abstract academic, prospective, or hypothetical, and on this basis its application should be dismissed. Of course, it must be noted that the Foundation was at liberty to bring a different case before this court, where it could have sought to declare a particular display of the flag as hate speech, discrimination, or harassment. If such a case were brought, the court would be able to judge all the salient features of that event and make a proper determination on whether that display breached Papuda. Instead, the Foundation asked this court to pronounce on the abstract without being able to take account of the context of the future displays of the flag. I'll now turn to this question as to whether the term words used in Section 10 can be interpreted to include a flag. And I'm going to cite something that's often cited in our law reports from Alice in Wonderland. When I use a word, Humpty Dumpty said in a rather scornful tone, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make words mean so many different things. Now, in the Hyundai Motors matter, the court sort of sets out what principles must be used when interpreting legislation. Judicial officers must prefer interpretations of legislation that fall within constitutional bounds over those that do not, provided that such an interpretation can be reasonably ascribed to the section. Limits must be placed, however, on the application of this principle. On the one hand, it is the duty of a judicial officer to interpret legislation in conformity with the Constitution, so far as this is reasonably possible. On the other hand, the legislature is under a duty to pass legislation that is reasonably clear and precise, enabling citizens and officials to understand what is expected of them. A balance will often have to be struck as to how this tension is to be resolved when considering the constitutionality of legislation. There will be occasions when a judicial officer will find that legislation, though open to a meaning which could be unconstitutional, is reasonably capable of being read in conformity with the Constitution. Such an interpretation should, however, not be unduly strained. I'll read a few extracts from the National Coalition case. It is true, a principle of constitutional interpretation that where it is reasonably possible to construe a statute in such a way that it does not give rise to constitutional inconsistency, such a construction should be preferred to another construction, which, although reasonable, would also give rise to such inconsistency. Such a construction is not a reasonable one, however, when it can be reached only by distorting the meaning of the expression being considered. In Natal Joint Pension Fund, the court held that judges must be alert to and guard against the temptation to substitute what they regard as reasonable, sensible, or businesslike for the words actually used. To do so in regard to a statute or statutory instrument is to cross the divide between interpretation and legislation. Something very fundamental here regarding the separation of powers. In other words, the proper function of a court is to reasonably interpret the legislation that was drafted by Parliament, not to supplant the legislative powers that Parliament has. It is not the role of this court to pass legislation that it would prefer to be the case. It is the job to interpret the legislation that has been delivered. In Chirwa, Lunga CJ echoed this by saying, "We must be careful as a court not to substitute our preferred policy choices for those of the legislature. The legislature is the democratically elected body entrusted with legislative powers, and this court must respect the legislation that it enacts as long as the legislation does not offend the Constitution." Finally, law also has a section on interpretation, and it says it's a well-established rule in the construction of statutes that where an act is capable of two interpretations, that one should be preferred which does not take away existing rights, unless it is plain that such was the intention of the legislature. What is contended by the applicants is to do exactly that, to interpret this in this obtuse manner to remove rights. There is currently a right to wave offensive symbols like the flag, and they want an interpretation which would take away that right and limit that freedom. Let's turn to what is meant by these terms, words and flags. The Merriam-Webster dictionary defines the term as follows, the term word: a speech sound or series of speech sounds that symbolizes and communicates a meaning, usually without being divisible into smaller units capable of independent use. Second, a written or printed character or combination of characters representing a spoken word. Third, any segment of written or printed discourse ordinarily appearing between spaces or between a space and a punctuation mark. How is a flag defined? a usually rectangular piece of fabric of distinctive design that is used as a symbol, as of a nation, as a signaling device, or as a decoration. Now, it's clear on the ordinary meaning of these terms that the term words does not refer to symbols like flags. There are... Now, I think what's important is that if we think about, there are broad categories of terms, like the term expression, or the term speech, arguably. Now, the term expression, one can express oneself in a number of ways. You could do it through interpretive dance, through painting, or through words. Section 16.1 of the Constitution uses this broad term expression, and it is AfriForum's case.
I might be taking ahead the argument. The definition you have just read from Merriam-Webster
Yes.
says words mean a speech.
A speech sound. In other words, those that are uttered. In other words, an oral use of words. So in other words, if I express myself with words orally or in writing, those are words. To make the claim that speech being, in other words, the Americans use that term speech to include other expressive activity, well, that's not included in the term words. I might explain it in a simple way, which is to say, let's say we have the broad category of animals. And we have giraffes and donkeys and dogs, and they're all animals. It is the case that a donkey is an animal, and that all donkeys are animals, but it is not the case that all animals are donkeys. In other words, what my learned friends have done is make this error in order to assume that, well, the terms can be interchangeable. Because words are a form of expression, they then want to say that all words are expression, and that expression encompasses this broader category. That is a logical error. In other words, there are these subcategories under expression, one of which is words, one of which might be the symbolic use of symbols, or painting or dance or whatever it is. But it is not the case that words are the same as dance, or that they're the same as painting. They are a mere category of expression. Furthermore, there's something interesting regarding what the Human Rights Commission itself says about whether the 1928 flag is hate speech in terms of Maputo. They state in their affidavit, Section 10 of Maputo specifically prohibits the publication, propagation, advocacy or communication of words based on one or more of the prohibited grounds contained in Maputo. Section 10 therefore restricts the type of expression which may constitute hate speech to words only. As a result of this restriction, symbols, pictures, and other non-verbal forms of communication, such as the display of a flag, can never be considered hate speech under Maputo on the basis that such communication will not amount to words in the ordinary sense. Stated differently, it is difficult to interpret words so broadly as to include the display of a flag, such as the old flag, without ignoring the language of this provision. I'm advised that applying ordinary principles of statutory interpretation, words probably does not encompass the display of a flag, at least a flag which does not contain any words on it. The Minister states, the Commission is correct in noting that Maputo, which sets out the statutory prohibition on hate speech, is a prohibition that pertains only to words and requires that the words communicated demonstrate a clear intention to be hurtful, be harmful, or to incite harm, promote, or propagate hatred. Now, in other words, it was the case of the Human Rights Commission in their initial affidavit to say this is untenable. It would be unduly strained to interpret this term words to include a flag. They have done an about-face, an argument, to say that this can be done. Now, one of the reasons that they say that the heading in Maputo uses the term hate speech, and this indicates that the term word should be interpreted to have a broader meaning. However, in the matter of Turfentine Estates, Innis, Chief Justice, stated the following: where the intention of the lawgiver as expressed in any particular clause is quite clear, it cannot be overridden by the words of a heading. In other words, to say that this refers to hate speech and that speech is some broader category doesn't help us in the interpretation of the term words. But really, it's pretty clear what's happening in Maputo. It says, if we want to work out what hate speech is, we read Section 10, and it's confined to words. That is the definition of hate speech. There might be other colloquial definitions of the term, which may include other categories, but the legislature decided to confine it to words, which are a particular form of communication. Now, my learned friend makes the claim that that the other words used in that section, propagate, advocate, they don't make sense when talking about words. Well, what appears to be happening is that it is ideas which are communicated through words which are prohibited through that section. So it's the particular vehicle of communication that is being targeted in Papuda. And so, understood in that light, it is perfectly logical for the term words to be used, because that is a particular vehicle. Furthermore, our courts have already determined what the meaning is of Section 10.
Are you done with your own submission on words?
Almost. I'm going to now look at some precedents from this court on what that term means in the legislation. So, in the matter of Sonke Gender Justice versus Malema, the court looked at this question as to what is meant in Section 10 and said, thus, any words communicated may amount to hate speech if they meet the above criteria set out in Section 10. It should also be noted that Section 10 expressly refers to words and not to a picture or non-verbal forms of communication. In other words, the Equality Court has already looked at the legislation and said words mean words, and they do not refer to pictures or non-verbal forms of communication. In other words, there's a precedent on this very point. On the importance of that precedent, in Robin Consolidated Industries, the SCA held that, I should state again that for good reason, this court is reluctant to depart from its own decisions, and that once the meaning of the words of a section and act of Parliament have been authoritatively determined by this court, that meaning must be given to them even by this court, unless it is clear to it that it has erred. So this court ought to be reluctant from departing from the meaning attributed to the term words when other equality courts have already made that finding. Now, the Foundation has relied on some defamation cases to try and make the claim that expression refers to things beyond words. Now, I'll focus on LaRue versus Day because that was the one that they referred to. Now, the passages that they state are as follows. It is well established that the determination of whether a publication is defamatory and therefore prima facie wrongful involves a two-stage inquiry. I use the word publication to include a pictorial representation such as a photograph. The first is to determine the meaning of the publication as a matter of interpretation, and the second whether that meaning is defamatory. Publication means the communication or making known to at least one person other than the plaintiff. It may take many forms. Apart from the obvious forms of speech or print, the injurious information can also be published through photographs, sketches, cartoons, or caricatures. Now, the court in LaRue does not use the term words. It uses the term publication. Therefore, the case is not authority for the proposition that words includes the 1928 flag. Furthermore, the law of defamation is not codified in a statute. It is part of the common law and does not refer to the term words. In other words, again, this logical error has been made to say, well, in the case of defamation, images can be defamatory. Well, when we're talking about publications, we know that publications can include a variety of subclasses, which include words, pictures, etc. But Papuda uses a confined term, that being words only. If it used the term publication or expression, that would be a different matter, but the legislature did not do that. So that is my submission on why words must be understood in its ordinary sense. It is a submission that was initially supported by the Human Rights Commission and by the Minister. Next question is...
You know the question which I raised you on this one?
Yes, about Morse code and Morse code and hand signals.
Yes, and also the question of... Let me put it to two. I'm being invited to give a wider interpretation of words. To say, when we say words hurt, we don't mean let us put together hurt. We mean the meaning of words. So I'm being asked to say words include meaning, not just
Yes.
That is one leg of my question. I'll just put them so that you answer both and then go on. The second one is sign language. The act as it is, using the word words, be interpreted to say sign language which says exactly what words we have said, but which does not words. It's not covered by that section.
Yes. So, my Lord, on the first point, it is true that words convey meaning, and symbols can convey meaning, pictures can convey meaning. To say that, in other words, the prohibition must be anything that contains meaning, is again to...
Let's talk about interpretation.
Yes. In other words, what we must, in doing that interpretive exercise, must look at the words used in the legislation and look at their ordinary meaning. Now, it is the case that words convey meaning and that words can be hurtful. I accept that...
Can words be hurtful without the meaning behind words being hurtful?
I would think in order to understand... In other words, let's say someone spoke...
When we say words, don't we actually refer to their meaning?
Yes, words are a particular vehicle to convey meaning. And so, for example, if someone said something to me in a language I'd never heard before, the fact that the words themselves are not necessarily hurtful, it's the meaning that needs to be conveyed for me to experience the hurt. I accept that other vehicles can express meaning and can convey hurt. But again, to say that it's to make the same logical error. In other words, because different vehicles can get you to one point, they're not the same. It is a particular way to get there. The second point regarding other forms of...
Are there words in sign language?
No.
And are therefore, in the law as it stands, people who use sign language, are they free to commit any hate speech just because they don't use words? The act doesn't prohibit their speech. But don't they have speech?
Well, I would think precisely because someone cannot express themselves through verbal words or possibly through written communication, that they would use sign language. This appears to be, in other words, a form of communication, that it does not amount to words. I would say that Morse code, again, there's an argument that it wouldn't be words, but it can convey meaning. But the legislature, for better or for worse, picked that limited term of words. They could have picked other terms. And I'll give an example of where they did, or are attempting to do so.
Is
Which,
your short answer to say hate speech in terms of South African law as it is can't be committed by those who use sign language? You can give me other examples, but is that the effect of your submission?
yes. You might prefer it to be otherwise. In other words, it would be preferable if the legislature had drafted more carefully. In other words, if they had said, and I will give this example.
But it would then mean that they would have to say, in whatever they say, including hate speech, including sign language.
Well, my Lord, I'll explain how this was intended to be resolved. The new hate speech bill, which the minister...
Yeah, I was hoping nobody's going to waste time.
Well,
That is what it is a bill.
yes, it's a bill. It is not a force of law. But I'll explain, in other words...
You being the respondent, of course, we can use it to illustrate whatever.
Yes.
But please let's not stay long.
Not for very long, my Lord. So, at page 286 of the bundle, the main bundle, the proposed offence of hate speech is set out. At section 4, the language that's used is, any person who intentionally publishes, propagates, or advocates anything or communicates to one or more persons in a manner that could be reasonably construed to demonstrate a clear, etc. The legislature there used very different language to Papuda. They said, publishes, propagates, or advocates anything. That's going to include the Morse code, the pictures, the symbols, the sign language. It's very clear that these two things mean different things. And Parliament has the power to produce legislation that looks like that if they want to do so. They did not elect to do that with Papuda. In other words, it may have been better for them to have done so, but they didn't. And as I say, this court must interpret the words as it finds them in their ordinary meaning. Now, the next important question then is, in other words, if there was an alternative way for this legislation to be drafted, it could have been more conclusive. Is the fact that it's not somehow unconstitutional? And so now it's important to sort of understand, what would make legislation unconstitutional. And I'll start by looking at Section 39(2) of the Constitution, which states that when interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. And to determine whether the use of the term words is constitutional, the ambit and value of the right to freedom of expression must be considered in conjunction with other associated rights. So this is really at the heart of this matter, is to talk about the importance of free speech. It is the reason why AfriForum has participated in this manner, is to explain the importance of this right. And I think it's worth pointing out that Nelson Mandela himself talked about the importance of freedom in A Long Walk to Freedom. He said the following. It was they're on page 80 of the bundle, paragraph 9. Not in the heads, in the bundle itself. Yes. So in A Long Walk to Freedom, he says, "It was during those long and lonely years that the hunger for the freedom of my own people became a hunger for the freedom of all people, white and black. I knew as well as I knew anything that the oppressor must be liberated just as surely as the oppressed. A man who takes away another man's freedom is a prisoner of hatred. He is locked behind the bars of prejudice and narrow-mindedness. I'm not truly free if I'm taking away someone else's freedom, just as surely as I'm not free when my freedom is taken from me. The oppressed and the oppressor alike are robbed of their humanity."
When I read that phrase, I looked at the interpretation, which we look at pre-1994 and post-1994. In pre-1994, the oppressor and the oppressed alike were robbed of their identity. Isn't the place where they belong, post-1994, united in that diversity?
Yes, I would think so. That part of our democratic project is to accept that we have a society of diverse peoples with diverse interests, and that our diversity should be celebrated. But we must also recognize that diversity requires tolerance. In other words, we think about this idea of tolerance grew out of religious difference, that Catholics and Protestants decided to tolerate each other, not because they liked each other's beliefs, but because they disliked them. They said, I don't like the fundamental nature of what you believe. I disagree with you, but I will let you do it. I will tolerate it. That religious tolerance is an enormously powerful way of preventing people from...
But the quote here almost said, we need to bring both the oppressor and the oppressed. It doesn't say the oppressor must tolerate the oppressed or the oppressed must tolerate the oppressed. Bring both.
Yes, well, the implication is that when you take away someone's freedom, that you then become this prisoner of hatred, and that you may want to take away someone's freedom because you don't like what they're doing. So during apartheid, the National Party banned the ANC. They banned their regalia. They said, we don't like this. We're going to deny you this freedom. They understood them as a terrorist organization. They banned books aplenty on the grounds that they thought that those freedoms being expressed were unconscionable, that people that were reading pornographic materials were doing something wrong and that freedom should be taken away from them. Now, the idea is that in a free society we say, I don't necessarily like what you do, I don't endorse what you do, but your freedom to do it must be protected provided that you do it within a certain ambit. And
That I understand. So it's just this expression. It's almost saying, if I ban what you are reading, you're saying you're oppressing me. I think both of us is for me to appreciate the craft.
Yes, I think it's to recognize that in order for both of us to be truly free, we have to give each other freedom, even if the expression of those freedoms is not the kind of thing that we appreciate or like. We have to tolerate it. And on this point, I mean, if we think about, my learned friends have spoken about the 1928 flag as being a symbol of oppression, a symbol of an apartheid state, a symbol of colonialism. If we think about the Springbok symbol used by the South African rugby team, this was viewed by many, legitimately so, as a symbol of oppression. This was the symbol used by a team that was racist. It denied people, on the basis of the color of their skin, the ability to participate in the team. And it was fair for people to argue that this is a symbol of the past and it should be jettisoned. And Nelson Mandela himself said, we need to understand that these symbols have multiple meanings, that he himself wore that Springbok jersey in an incredible act of reconciliation. In other words, to say that we don't reject all symbols because of their particular past. Some of them can be incorporated, some of them can be respected, we don't have to like them. In the case of that particular symbol, the meaning shifted dramatically from a racist symbol to one of inclusion. But to now talk about the importance of free speech, I'll talk about the South African National Defence Union case. I'm back at my heads. The Constitutional Court there held that freedom of expression is one of a web of mutually supporting rights in the Constitution. It is closely related to freedom of religion, belief and opinion, the right to dignity, as well as the right to freedom of association, the right to vote and to stand for public office, and the right to assembly. These rights taken together protect the rights of individuals, not only individually to form and express opinions of whatever nature, but to establish groups and opinions of like-minded people to foster and propagate such opinions. The rights implicitly recognize the importance both for a democratic society and for individuals personally of the ability to form and express their opinions, whether individually or collectively, even when those views are controversial. So let's have a look at freedom of expression itself. I will be talking about freedom of expression for the most part and then go into these other associated rights as well. But the Constitution creates protection for expression by proclaiming that everyone has the right to freedom of expression, which includes freedom of the press and other media, freedom to receive or impart information or ideas, freedom of artistic creativity, and academic freedom and freedom of scientific research. Now, the term that is used here is not freedom of words, it's freedom of expression, as my learned friends have pointed out. Expression being this very broad category. That is what is in the right. It is this broad protected right. And the right to wave an offensive flag is going to fall in that right because it is a form of expression. In De Coco, the court held that freedom of expression is the lifeblood of an open and democratic society cherished by our own Constitution. And again, in National Defence Union, it lies at the heart of a democracy. It is valuable for many reasons, including its instrumental function as a guarantor of democracy, its implicit recognition and protection of the moral agency of individuals in our society, and the facilitation of the search for truth by individuals and society generally. The Constitution recognizes that individuals in our society need to be able to hear, form, and express opinions and views freely on a wide range of matters. And in Phillips, the court goes so far as to say this: under the new constitutional dispensation of this country, expressive activity is prima facie protected no matter how repulsive, degrading, offensive, or unacceptable society or the majority of society might consider it to be. In other words, expressive activities cannot be excluded from the scope of the freedom guaranteed by Section 16 on the basis of the content or meaning being conveyed. So there are really four main reasons why free speech is so valuable. First, it aids us in the search for truth. Second, it is vital for the functioning of a democracy. Third, it enhances moral agency. And finally, it instills tolerance. With regard to truth, allowing the free dissemination of beliefs and opinions and other forms of expression bring immense benefits. It allows for intellectual, cultural, and scientific progress while provoking discussion and aiding the search for truth. Since we are fallible, we cannot know with certainty that a particular opinion is false. When we suppress opinions that are believed to be false, we risk missing out on the truth. And by stifling opinions that are different from our own, we lose the opportunity to challenge, reconsider, and perhaps reaffirm our own views. In Mamambalo, the court held that free speech, especially when engaged in conjunction with its accompanying fundamental freedoms, is of the utmost importance in the kind of open and democratic society the Constitution has set as our aspiring norm. Having regard to our recent past of thought control, censorship, and enforced conformity to government theories, freedom of expression, the free and open exchange of ideas, is no less important than it is in the United States of America. It could actually be contended with much force that the public interest in the open marketplace of ideas is all the more important for us in this country, important to us in this country, because our democracy is not yet firmly established and must feel its way. Therefore, we should be particularly astute to outlaw any form of thought control, however respectably dressed. Now, really, the arguments raised by my learned friends are respectably addressed. There's this idea that apartheid is a crime against humanity, which is acknowledged by AfriForum. It was an awful atrocity committed against all South Africans, black South Africans in particular. And there's this temptation to say that any symbol of that regime ought to be censored by the law. And I can understand that impulse. But at the same token, in a new democratic society, in a new constitutional order, we have to accept that some people in our society are going to express views that are repugnant, that are offensive. And that one way to get to the truth of the matter is to combat those ideas, to point out to those people in public, your views are wrong for these reasons, and to explain why. You know, the risk of censoring an idea is that we no longer understand the reason why the idea itself is bad, and that it's important that we combat it openly so that it can be denounced and so that it can never raise its ugly head again in real actions. In other words, only in speech, that it can be rebutted again and again. So, as I say, it is the cornerstone of a functioning democratic state. It gives the people gives people the opportunity to be exposed to differing viewpoints and to make informed and legitimate decisions about their political and private lives. In Kamalo, Justice O'Regan said, "Without free speech, the ability of citizens to make responsible political decisions and to participate effectively in public life would be stifled." The idea is that people are actually exposed to a range of different ideas. They can make the choices themselves. It's not enforced or required by the state. Ronald Dworkin, one of the greatest legal philosophers, says the following: "Morally responsible people insist on making up their own minds about what is good or bad in life or in politics, or what is true or false in matters of justice and faith. Government insults its citizens and denies their moral responsibility when it decrees that they cannot be trusted to hear opinions that might persuade them to dangerous or offensive convictions. We retain our dignity as individuals only by insisting that no one, no official and no majority has the right to withhold an opinion from us on the ground that we are not fit to hear and consider it." There's this concern that, again, that if citizens feel that everything has been curated for them, that the bad stuff has been taken out, that they assume that what is before them is true. And this is the danger of a repressive government like the apartheid regime, where information was taken away from citizens, so they couldn't really come to grips with all the ideas that were available. And you wind up with a populace that has its dignity undermined, that has its agency taken away from it. And we should not make that dangerous error again. Now, I've spoken a little bit about tolerance. In the national defense case, the court held that the corollary of freedom of expression and its related rights is tolerance by society of different views. Tolerance, of course, does not require approbation of a particular view. In essence, it requires the acceptance of the public airing of disagreements and the refusal to silence unpopular opinions. In other words, to tolerate something is not to say it is good. It is really to say, I don't like it, but I will tolerate it nonetheless. Denise Meyerson, who South African legal academic who has recently come back to give a guest lecture at Wits, said the following on this matter: "To drive an evil view underground can actually increase its strength, whereas to debate it out in the open is more likely to bring home its abhorrent nature. It is precisely those who, after all, believe there is a truth about the awfulness of racism who should be optimistic about the power of debate and argument to demonstrate that truth. They came to their views by reason, and since they do not believe themselves to be intellectually superior, should trust in reason rather than the police force as the better weapon against falsehood. It is only too easy for censorship laws to be put to different uses from those originally intended, and if we are happy for them to be deployed in one way, we make it much easier for them to be deployed in other, more frightening ways later. And a final consideration here is that to the extent that racial animosities will continue to plague us, it is better to let them be played out at the level of words rather than to bottle them up, thereby not only increasing their virulence, but also making more likely a more dangerous kind of discharge. Forced as we are to weigh up evils here, we should therefore conclude that tolerance is more beneficial than costly. So we have an idea of what is envisaged by this free speech right and why it is so important. Now come to grips with what are the limitations of that right. So 16.2 says the right does not extend to propaganda for war, incitement of imminent violence, or advocacy of hatred that is based on race, ethnicity, gender, religion, and that constitutes incitement to cause harm. The authors of the Constitutional Law of South Africa state that the starting point in assessing the constitutionality of hate speech legislation is to establish whether or not the prohibited expression falls within the meaning of this section of the Constitution. If the prohibition is synonymous with, or more limited than the type of hate speech contemplated, the legislation will pass constitutional muster. In Islamic unity, the court says, how is section 16.2 to be interpreted? The words the right in section 1 does not extend to imply that the categories of expression enumerated in 2 are not to be regarded as constitutionally protected speech. 2 therefore defines the boundaries beyond which the right to freedom of expression does not extend. In this sense, the subsection is definitional. 2C is directed at what is commonly referred to as hate speech. What is not protected by the Constitution is expression or speech that amounts to advocacy of hatred that is based on one or other of the listed grounds, namely race, ethnicity, gender, religion, and which amounts to incitement to cause harm. There is no doubt that the state has a particular interest in regulating this type of expression because of the harm it may pose to the constitutionally mandated objective of building the non-racial and non-sexist society based on human dignity and the achievement of equality. There is accordingly no bar to the enactment of legislation that prohibits such expression. Any regulation of expression that falls in the categories in 2 would not be a limitation of the right in 1. Now, Peter Foster says something quite interesting on this. He says 16.2 of the Constitution does not prohibit or regulate hate speech. Instead, it lists types of speech that are not protected by the Constitution and that could, therefore, be regulated or prohibited by the legislature without infringing on the right to freedom of expression in 16.1. Now, my learned friend for the Human Rights Commission at one point made the claim that the Constitution itself prohibits certain kinds of speech, namely the advocacy of hatred. It does no such thing. The Constitution in this section is definitional. In other words, it grants a power to Parliament to produce legislation that goes up to that limit, but it does not itself prohibit anything. In the matter of Masuku, the SCA said, the starting point for the inquiry in this case was that the Constitution in 16.1 protects freedom of expression. The boundaries of that protection are delimited in 16.2. The fact that particular expression may be hurtful of people's feelings or wounding, distasteful, politically inflammatory, or downright offensive does not exclude it from protection. Public debate is noisy, and there are many areas of dispute in our society that can provoke powerful emotions. The bounds of constitutional protection are only overstepped when the speech involves propaganda for war, the incitement of imminent violence, or the advocacy of hatred that is based on race, ethnicity, gender, religion, and that constitutes incitement to cause harm. The contention that a more extensive definition of hate speech can be justified under Section 36 is at the least debatable, as 16.2 provides an internal limitations clause. In the matter of Moyo, the SCA held that unless hate speech, incitement of imminent violence, or propaganda for war as prescribed in 16.2 are involved, no one is entitled to be insulated from opinions and ideas that they do not like, even if those ideas are expressed in a way that place them in fear. Indeed, in present-day South Africa, many will be afraid of the political and social possibilities that are advocated for daily in high-stakes debates that characterize a transforming society with a violent racist past. Obviously, this may place many South Africans in a condition of subjective or reasonable fear, but that does not entitle them to expect the state to lock up those whose chosen form of expression place them in a subjective state of fear or might reasonably, but not in fact, have placed them in fear. even expressive acts that create reasonable fear are deserving of constitutional protection, unless they are accompanied by threats of violence on which the person making the threat is capable of acting, or they constitute unprotected expression as defined in 2. Fear-creating expressive acts are lawful, even if they are aggressive and hostile. In Hotz, the court said, a court should not be hasty to conclude that because language is angry in tone or conveys hostility, it is therefore to be characterized as hate speech, even if it has overtones of race or ethnicity. Now, as I've stated earlier, advocacy of hatred could refer to expression which includes words, symbols, and flags. In other words, what's used in 16.2. However, the section does not prohibit any form of expression. It means that such protection is not protected. Such expression is not protected. The fact that such expression is not protected means that the legislature may choose to prohibit such expression, but it has no obligation to do so. While the legislature had the power to prohibit expression over and above words, it has no obligation to do so. Choosing to only prohibit words is not unconstitutional because the Constitution creates no direct prohibition in any form of expression. Now, my learned friends have spoken quite a lot about dignity, so let's have a look at what dignity means. In the Constitution, it states that everyone has inherent dignity and the right to have their dignity respected and protected. Now, Justice Ackerman in Ferreira says the following about the relationship between freedom and dignity. Human dignity has little value without freedom. For without freedom, personal development and fulfillment are not possible. Without freedom, human dignity is little more than an abstraction. Freedom and dignity are inseparably linked. To deny people their freedom is to deny them their dignity. With regards to equality, the Constitution says that everyone is equal before the law and has the right to equal protection and benefit of the law. Judge Sachs says the following in the Ferry case. Equality means equal concern and respect across difference. It does not presuppose the elimination or suppression of difference. Respect for human rights requires the affirmation of self, not the denial of self. Equality, therefore, does not imply a levelling or homogenization of behaviour. Parliament's choice not to prohibit symbols means that all symbols are treated equally, in that none of them are prohibited. It is not arbitrary to regulate words and not symbols, since symbols may be harder to interpret. Now, to explain this point properly, let's have a look at a couple of symbols that...
Someone says symbols may be easier to interpret than words.
Yes. Now, to my mind, the paradigmatic case of a symbol that most people look at and say, this is a hate symbol, is the swastika. Now, here's the difficulty. In Asia, the symbol is commonly found on Hindu and Buddhist temples, and what it signifies is the auspicious footprints of the Buddha. So it depends on the context in which it's used. In other words, when the Nazis used it, it was a symbol of anti-Semitism, of white supremacy, of an extermination of a people. When Hindus and Buddhists use it up until today, it doesn't mean that at all. And so it's not to say that Parliament, that it's impossible to regulate symbols. It's to understand that there may be a legitimate reason why Parliament decided to limit itself to words. That there's always going to be this difficulty. I mean, the other interesting example is the number 88. So some people will be aware of a thing called ham radio. So before the internet and before cell phones, people used to communicate on these radio devices, and they would use shorthand signals, and 88 meant love and kisses. What it means to neo-Nazis is Heil Hitler, 8 being synonymous with H, and HH being Heil Hitler. In other words, we have a symbol that literally means two different things. And what you find as well with symbols is that there's this treadmill that happens. In other words, once one symbol is clamped down and banned, those people their ideas don't change. They don't stop believing in hatred and racial exclusion. They just find some other symbol to express that. And so the difficulty is that you have this treadmill with symbols that's very hard to stop. And so Parliament may have had a legitimate reason to have confined the regulation to the term words. Although, as I say, AfriForum's case is that they had the power to go beyond that. There is reason to understand why they may not have. And this is because there's a claim that it was utterly absurd not to have regulated symbols, and this is an argument for why it might not be absurd. The other thing that must be recognized is that, and Josie Pride point this out very well in their papers and the foreign case law that they draw upon, that those countries which have regulated symbols have done so in a very detailed and precise manner. They've passed legislation that lists the particular symbols. You know, it says the hammer and the sickle, 5-pointed star, the swastika, you know, and then gives examples of, you know, when that would be protected speech and when it wouldn't. For example, Germany, up until very recently, had a ban on the use of the swastika in video games. And the idea was that they saw video games as immersive, and that Germans being exposed to this hateful symbol could be dangerous. And there was a backlash. There's a game in which one plays a Nazi hunter called Wolfenstein. And in the international versions of that game, people can go and hunt the Nazis, and they can kill the Nazis, and they can see Hitler, and they can see the swastikas, and recognize this is an evil regime to combat it. And in Germany, what you had was that the swastikas were turned into triangles, that Hitler was called something else, and his moustache was removed. And it starts to amount to a kind of distasteful denialism to imply that this event didn't occur. And so there's reasons why you want to allow symbols in certain cases. That if you're going to put on a production of The Sound of Music, you want to be able to use the swastika so that you can show the stormtroopers coming in and point out that these people are bad people instead of denying that the event ever occurred. So the reason why I mention this is to say that those states that have decided to prohibit symbols have done so very explicitly. Parliament has done it. It hasn't been done by the courts. It's been done in this very careful, explicit manner. The next right that I'm going to talk about is the right to freedom of thought, belief, and opinion. The Constitution says everyone has the right to freedom of conscience, religion, thought, belief, and opinion. And in the Constitutional Law of South Africa, the authors state that this right is aimed at ensuring that everyone is free to adhere to deeply held beliefs and values, whether they are derived from religion, a system of personal morality, or a secular worldview. A set of deeply held opinions or convictions can form a comprehensive view of the good life comparable to any and all conventional religious faiths. Viewed in this life, the protection of opinions is not inconsistent with the protection of thought or belief, nor is it necessarily incongruous in a clause concerned with recognizing the individuality, freedom and dignity of every person and the diversity of ideas. The Constitution also recognizes that everyone has the right, peacefully and unarmed, to assemble, to demonstrate, to picket and present petitions. In the matter of Satawu, the Constitutional Court held the right to freedom of assembly is central to our constitutional democracy. It exists primarily to give a voice to the powerless. This includes groups that do not have political power or economic power, and other vulnerable persons. It provides an outlet for their frustrations. This right will in many cases be the only mechanism available to them to express their legitimate concerns. In Turrell, the court held that freedom of expression freedom of speech and freedom of assembly are part of the democratic rights of every citizen in the Republic, and Parliament guards these rights jealously, for they are part of the very foundation upon which Parliament itself rests. Free assembly is the most important right, for it is generally only organised public opinion that carries weight. It is extremely difficult to organise if there is no right to public assembly. In CISO, the court held, in view of the provisions of the Constitution articulating and protecting this fundamental freedom, the court should be loath to give a strained or extended meaning to a statute which would, through such an interpretive process, seek to confer power to abridge or curtail the right to free assembly. This is what would occur in this matter. In other words, the applicants seek a strained reading of Papuda to prohibit public displays, which would of course have a knock-on effect for the right to freedom of assembly. In other words, those that want to protest under the flag would have those rights taken away from them. And this would be infringement of not only a free speech right, but of an assembly right. Now, the Mandela Foundation also say that the relief they seek is not only for public displays. In their papers they talk about private displays. So this is going to be an infringement of the right to privacy.
Do they, in the prayer, seem to say anything about space?
They use the term gratuitous displays, and they say gratuitous display, in other words, is all displays, barring these exceptions. And they specifically say in their papers, well, we think that includes a private display.
I know that referred to,
Yes.
but I don't have freedom, in my judgment, given what has been argued before me, to talk about displays in private
Well, to my mind, it would to restrict private displays would be an infringement of the right to privacy, and would.
Even the invitation they have given to me, you are still going. You had them argue.
Yes. Well, if the point has been abandoned, in other words, if they don't seek the regulation of private displays,
Really
then I will.
it may not be necessary, even how they argue the case, for you to address me on what you've written here under the right to privacy.
Yes.
I meant to say, I've read each and every way what all of you have written here. So this is really the opportunity for you to make a high point.
Yes.
Emphasize where you want to make that.
Yes.
When I say privacy is not relevant, I've read everything you have said, including reference to cases which you have made there, because I wasn't quite sure what's coming.
Yes.
I was just saying to you, given what has come out in this address, is that still something on which I find express?
Well, my lord.
Can you just clarify?
Okay. Yep.
And Lord, we are persistent with the argument that both public and private constitute gratuitous displays if they are not protected by Section 12.
That is, I've always been listening to them, it's just as well I raised it. Now I know what the argument.
Then, my lord, I will explain what our constitutional rights to privacy entail.
I have said, but each and every word you have said there, you're welcome to read whatever you want to. I'm here to be convinced, so use the opportunity to convince me.
Yes, I understand, George. Well, my lord, given that in other words, their relief is so broad as to want to invade a private person's home to remove the flag from their dinner table or from their braai space, it must be understood that the right to privacy is impacted. So everyone has the right to privacy, which includes the right not to have their personal home searched, their property searched, their possessions seized, or the privacy of their communications infringed. The right to privacy embraces the right to be free from intrusions, interference by the state, and others in one's personal life. Now, Judge Didcott, in the matter of case, looked at the question about pornographic materials, but there's an analogy here on the grounds that both materials are deemed offensive. He says, "What erotic material I may choose to keep within the privacy of my home, and only for my personal use there, is nobody's business but mine. It is certainly not the business of society or the state. Any ban imposed on my possession of such material for that solitary purpose invades the personal privacy which the interim constitution guarantees that I shall enjoy." So the above-mentioned rights stand as bulwarks against censorship and the prohibition of flags and symbols. Interpreting Papuda in light of these rights would not favour a removal of the term words. So I mentioned these rights for two reasons. The first is to determine whether Papuda, as it stands, is unconstitutional, and my argument is that it is not. In other words, with regards to the use of the term words, that it is perfectly within Parliament's power to have used that narrower term instead of using a term like expression, and that when all of the rights are read in conjunction, that they are supportive of that. In other words, they protect not just the right to free speech, but the rights to freedom of assembly, dignity, equality, and of privacy. Now, my learned friend for the Human Rights Commission talks about international law obligations. I think it's important to know, well, what is the ambit of international law, and how is it playing a role in the interpretation of the statute? So, in terms of 233 of the Constitution, when interpreting any legislation, every court must prefer any reasonable interpretation of the legislation that's consistent with international law over any alternative interpretation that is inconsistent. Now, as I've already argued, it is not reasonable to interpret the term words to encompass the 928 flag, and so the injunction to use international laws and interpretive aid takes the matter no further. The Constitution also says that any international agreement becomes law in the Republic when it is enacted into law by national legislation. And 2H of Papuda states that one of the objects of the Act is to facilitate further compliance with international law obligations, including treaty obligations, in terms of amongst them the Convention on the Elimination of All Forms of Racial Discrimination. In Glenister, the court held that an international agreement that has been ratified by resolution of Parliament is binding on South Africa on the international plane, and failure to observe the prohibitions of this agreement may result in South Africa incurring responsibility towards other signatory states. An international agreement that has been ratified by Parliament under Section 231(2), however, does not become part of our law until and unless it is incorporated into our law by national legislation. An international agreement that has not been incorporated in our law cannot be a source of rights and obligations. In Azapo, it was held that international conventions and treaties do not become part of the municipal law of our country, enforceable at the instance of private individuals in our courts, until and unless they are incorporated into the municipal law by legislative enactment. The national legislature chose to meet its international obligations by enacting PAPUDA. The language used in international law instruments does not override or supplant the language used in national law. Therefore, the term words must remain in place. So in other words, if international law instruments use broader terms like expression or advocacy of hatred, well, that plays no role whatsoever. Now, on the question of what constitutes hate speech, my learned friend spoke a little bit about the recent judgment given by your brother Sutherland in the Kamalo case. Now, I think it's important to sort of explain how PAPUDA was interpreted before that matter, with reference to two cases, Hauselman and the matter of Penny Sparrow.
Disjunctive and conjunctive interpretation.
Yes, yes. So in other words, the way that PAPUDA is drafted,
What would be your submission? Must we go conjunctive or disjunctive?
it must be conjunctive. And the reason why it must be conjunctive, in other words, all three must be present, is that is the only way to interpret the legislation to be constitutional. It doesn't do any violence to the language of the section. In other words, what we have are these semicolons. If there were ors in there, well, then it would do violence to the section to say that they must be read as ands.
What should I make of the fact that legislature writes A, B, C, D instead of just continuing one step?
Well, in other words, there's what the court recognized in Kamalo is that there was an ambiguity. In other words, you've got A, B, C, and there is no use of or use of an and. And the question then becomes, well, how should this be interpreted in order to render it constitutional without changing any of the language? And the court held that the only way to do so is to read them as conjunctive, that it's an and list. And the reason...
I have seen that in Kumar.
Yes, and the reason is because that's what's used in the Constitution. Section 16(2)(c) says, you know, the advocacy of hatred on one of the listed grounds, and that constitutes incitement to cause harm. So, in Kamalo, Judge Sutherland says that you must read these things together. In other words, if what we had was only hurtful speech was sufficient, well, what we'd be doing would be prohibiting speech that was clearly protected by the Constitution. If we think about the range of speech that can be hurtful, that doesn't incite harm or propagate hatred, it's immense. There are all sorts of words and expressions and books that hurt people's feelings, that they feel offended by. And the Constitution provides protection for those things. And that's why, in other words, PAPUDA must be read conjunctively in order for it to be read constitutionally. Now, I'll read out. Now, what's interesting about this, to say that I think in the public's mind there is this misapprehension about what the nature of the law is because of these prominent cases. So, Hauselman being the first case, the court there held that if one has regard to the purpose of the act, the object of the act, and the interpretive clause, it militates against the acceptance of the conjunctive approach. If one were to adopt a conjunctive approach, then racially discriminatory words, which are clearly hurtful and even harmful, which are directed at an individual, may not fall within the ambit of the act, simply because they may not per se promote or propagate hatred, because they were not uttered in a group context. Now, the facts in that matter was that the complainant was described as a baboon. Now, this is clearly hurtful speech, which the court finds. Doesn't find that it meets the other requirements of propagating hatred or inciting harm, and then finds, well, the only way that I can get to a finding that this is hate speech is to have this disjunctive approach, which is what the court does. And in Penny Sparrow, Hauselman is relied upon to find that referring to black people as monkeys constitutes hate speech. Now, there's a distinction to be drawn between genuine hate speech, in other words, if you have all three requirements, and hateful speech. In other words, speech that is racist, that's despicable, that we don't like, that you want to censure, but falls short of being genuine hate speech. In other words, this clearly would fall short of what is described in our Constitution, because there is no incitement to cause harm, there is no call to action. And so in Khumalo, the court goes into some detail to explain that. And says, plainly, Section 10 of the Equality Act must be read consistently with Section 16 of the Constitution. In order to achieve that result, all parties are agreed that all three subsections of Section 10.1 must be read conjunctively rather than disjunctively to achieve the alignment that produces that consistency. As a result, the factor of incitement must be present in the prohibited utterances. The court then considers Hasselman explicitly and says, that decision did not consider the impact of Section 16.2 of the Constitution. For that reason, in my view, having omitted an important factor that had to be considered, the decision is unsafe, and for further reasons is with respect clearly wrong. The court then refers to the Kalani matter and says it is held that incitement need not be proven for all of the Section 10 subsections because 10 is wider than 16 of the Constitution. In my view, this conclusion cannot be correct, as the effect of 16 is to establish the perimeter, or it may be prescribed in Section 10.1. And now that is exactly what the Constitution does. In other words, it says this is the framework in which the legislature may pass legislation. Absent consistency with Section 16 of the Constitution, 10.1 provisions would be unconstitutional. And the Equality Act expressly subordinates itself to Section 16.2c. The view that 10.1 would be disjunctively read is also espoused by the authors of Constitutional Law South Africa, but they too assume a disjunctive reading without explaining why it is consistent with Section 16. As a result, in my view, the contentions on behalf of the parties in this matter are therefore well made, and I endorse them and did not follow those decisions. Now, my own friend argued that this was obiter, but really what we have is the court determining what the legal framework is, which is to say that it is a conjunctive test, all three things must be present, and then finding that Mr. Khumalo was liable for hate speech, having breached the law. In other words, this is ratio. This is an application of the law to the facts. This is not a matter where there's an aside. This law was used to decide the case and is binding upon this court. Now, on this question of incitement, which Judge Sutherland said must be present, it indicates that speech must instigate or actively persuade others to cause harm. And we must look at the context and likelihood of that harm. So in the matter of Freedom Front versus the Human Rights Commission, it was held that in respect of Section 16.2 of the Constitution is whether a reasonable person assessing the advocacy of hatred on the stipulated grounds within its context and having regard to its impact and consequences would objectively conclude that there is a real likelihood that the expression causes harm. The closer the proximity or a causal link between the advocacy of hatred on the stipulated grounds and the harm, the more likely it is that the expression would be deemed hate speech. The more tenuous the proximity or causal link, the less likely it is that the expression would be deemed to be hate speech. There must be a real likelihood that the expression causes harm before it can be deemed to be hate speech. So it cannot be the case that it's merely abstract. There must be a good chance that the harm is going to occur. With regards to context, and this is really quite vital, in Lamont J. in the matter of AfriForum Malema says, the meaning of the words uttered by Malema was an issue. In order to understand the meaning of the words, it is necessary to place the words in their proper context. Words individually have meanings which are elastic, and that the meanings they can convey can vary substantially. Groups of words similarly have elastic meanings. The permutations increase as one adds to the equation the context in which the words were uttered, the circumstances in which the words were uttered, the way in which the words were uttered, the gestures which accompany the words, and what the words imply. In this whole equation, sight must not be lost to the fact that notwithstanding the words used, the speaker, when he composes the message he wishes to deliver to the audience, is able to compose it as to simultaneously convey multiple meanings to the whole audience and constituent parts of it. The occasion, the history of the conduct, and the response of the public and press, gesture and physical movement, crowd interaction, the words, including the expression and delivery of the words in a chant-like manner, are relevant to determine the context of the song. They all together contribute to the form and the manner in which the message was delivered. In other words, what we have in this case is to say it's not a matter of banning a phrase or a word. It's about making a declaration in a particular context and saying, given where this was uttered, who it was uttered to, what it was accompanied by, only then can it be determined whether it is a breach of Section 10. Because ultimately the section says, the intention must be reasonably construed. And so we can do that once we know what particular event we're looking at. And of course the difficulty with the applicant's case is that there is no particular event that they're looking at. They look prospectively, they look at all future events without any possibility of being able to look at a context. In the matter of Vajnai versus Hungary, which is a matter provided to this court by Josie Pride, there the court is looking at a conviction for someone who was wearing a 5-pointed red star, which was prohibited by the Hungarian state. And the court found in his favor and held that, in the court's view, when freedom of expression is exercised as political speech, as in the present case, limitations are justified only insofar as there exists a clear, pressing and specific social need. Consequently, utmost care must be observed in applying any restrictions, especially when the case involves symbols which have multiple meanings. In such situations, the court perceives a risk that a blanket ban on such symbols may also restrict their use in contexts in which no restriction would be justified. So let's look at this question about whether all gratuitous displays of the 928 flag are going to constitute hate speech. And the Foundation immediately concedes that not all displays are going to constitute hate speech. It accepts that displays that serve any genuine artistic, journalistic, academic purpose in the public interest would not be hate speech. So when journalists write about this case, this very case, and display the 1928 flag in their articles, they are doing so to inform their readers, not to promote hatred. When Nyanda Mabula, the famous painter, uses the flag in his paintings and installations, he does so for aesthetic reasons and to provoke discussion about South African politics. He is not inciting harm. When academics write about the history of the 1928 flag and use its image, they do so to further what we know about our history, and there is no objective intention to be hurtful. After accepting that context makes all the difference when determining whether displays of the flag constitute hate speech, the Foundation makes the error that all other displays, besides the 3 listed exceptions, will count. Now I'm going to provide 3 examples of cases that would fall into their category of gratuitous displays, but that we would ordinarily not think of as hate speech. The first is a service delivery protest. So if your lordship would imagine a group of black protesters who organize a march against their local municipality for failing to provide adequate water, electricity and housing. And the protesters claim that the municipality is behaving as badly as the National Party during apartheid, and they wave the 1928 flag to accentuate their point. For an objective reading, there is no intention to propagate hatred, be hurtful or incite harm against a racial or protected group. The intention is to draw attention to the plight of the protesters. In other words, and this sort of claim has been made by people like Julius Malema, who said that the ANC are acting just as badly as the National Party, or what is happening is worse than what happened under apartheid. And the ability to punctuate that with the use of the symbol, in that
It's likely that those protesters will actually wait the apartheid flag.
well, in other words, if the claim we know has been made in public, which is to say that this is as bad as apartheid,
Assuming that is the point I want to make.
yes.
How likely is it that they will actually go and look for that flag? What's the essential thing?
Yes, I think that's worth talking about in a little bit of detail.
Very similar.
Yes, so Nicholas Bauer, a journalist for ENCA, published a tweet which said that Black Monday protests are being discredited by people burning the new South African flag and wearing the old South
What's the
African flag.
label of the current South African flag at the Black Monday protest of 2018?
Well, what Mr. Bauer later did was to issue an apology. Yes. As far as I can tell, in other words, Mr. Bauer says that image was not from Black Monday protests, that he distributed that image irresponsibly.
Okay, so it's a contested image.
Well, it's not contested, in other words, because the very disseminator of the image acknowledges that the event did not occur, that it occurred 7 years before in a different country. But in other words, when seeing that image, a person might say, a person who would burn the new South African flag can be doing so for one meaning only, which is that they have disdain for this government, they want to bring back apartheid, they are racist. Yes.
Appreciation as to whether it was banned or not banned at that particular.
There's no evidence that one was banned. Now, but I raise this point to say that when we think of someone burning that flag, we imagine leaping to that thought that the only reason someone would burn the new South African flag is because they want to bring back apartheid, because they hate black people. And one of the examples that we give in our filing affidavit is a group of black protesters burning the new South African flag in protest because a ceremony commemorating the June 16th was moved from one venue to another. In other words, it had nothing to do with a longing for apartheid. It had to do with disdain for a particular political decision that was made. So the point is that people can use symbols in these ways, and the only way to determine what their meaning is to look at the particular instance. Now, here's another case I'm going to give, which is one I wrote about at the time of the filing of the heads, and may have seemed strange and unlikely, but has actually come to light, which is an anti-apartheid protest. So a group of protesters organize a march. Each protester is carrying the 928 flag and a box of matches. During the protest, the flags are set alight, and the objective intention is to show disdain for apartheid, not to promote hatred. Now, this is going to, in other words, be a display of the flag, a gratuitous display, according to the applicants, but one clearly where the intention is to show disdain for apartheid. This might seem like a strange case. But very recently, the ANC Youth League organized a mass book burning. They wanted to burn copies of a book about Ace Magashule on the grounds that they find the book distasteful, and they asked people to bring the old South African flag along to the burning so they could burn that as well. In other words, when people would have... The book burning was, by the way, called off. The ANC said that civilized people don't burn books, and the ANC Youth League capitulated. But the call at the time was to, in other words, display the old South African flag in order to burn it. That display clearly does not seem like it would have had the intention to promote hatred, at least against a racial group, but against the apartheid regime. A third case. So a group of soldiers wearing military regalia from 1900 to date have a parade. And those dressed up as World War II soldiers display the 1928 flag, being the flag that South African troops fought under against the Nazi regime. And the objective intention is to depict an historical event. Now, you must recognize that, in other words, apartheid comes in formally as a policy in 1948. The South African troops that fought and died against the Nazis carried the old South African flag. In other words, if soldiers who were fighting at the time, and some of them are still alive, wore that flag, it would not be to venerate apartheid. It would be to say that we fought against this fascist, evil regime, and this is the flag that flew at the time. So that context is going to play a role. So the true onus on the foundation is to show that each and every case of the 1928 flag being displayed would constitute hate speech. The above cases merely demonstrate the importance of context when determining whether a particular display meets the full test in the Buddha. Now, while there may be some cases where it will be obvious that displaying the flag will be hurtful, it will be harder to find cases where this is also the promotion of hatred and the incitement to cause harm, with the real likelihood that such harm will actually be caused. If such a case does present itself, then it ought to be dealt with on its own facts. And there is nothing stopping anyone from bringing such a case. In other words, if there are people displaying the flag, and it can be shown that they meet all the requirements in Papuda as read conjunctively, then someone can raise a claim that that constitutes genuine hate speech. That is not what the applicants have done in this matter. They've asked for something broad and prospective. Now, my learned friend for the foundation says that they also seek the displays to be determined as harassment and unfair discrimination, and they say that this is uncontested. It is contested. The AfriForum goes into it in the affidavit to explain why it would not constitute harassment or unfair discrimination. No argument was proffered as to why it would. I can explain briefly why the requirements would not be met. I will not go into it in too much detail because the substance of today really has been about hate speech. So Papuda talks in section 11, says no person may subject any person to harassment, and harassment means unwanted conduct which is persistent or serious and demeans, humiliates or creates a hostile or intimidating environment, or is calculated to induce submission by actual or threatened adverse consequences, and it is related to sex, gender or sexual orientation, and a person's membership or presumed membership of a group identified by one or more of the prohibited grounds or a characteristic associated with such group. So the relief sought by the Foundation is far-reaching. It seeks to declare all gratuitous displays of the flag as harassment. And one can certainly imagine cases where someone using the flag could harass someone with it. However, this does not mean that all of them are going to amount to harassment. For example, a private display, which is not aimed at another person, or in cases where all those witnessing the display are willing participants, they will not be subjected to unwanted conduct, and none of them will have been harassed. Therefore, the relief is overly broad and should be dismissed on that basis. Whether it constitutes unfair discrimination, well, Papuda has a sort of two-stage inquiry. The first is, does this constitute unfair discrimination? The second is, well, can it be rebutted? And so there's a burden of proof test there. And there must be a determination of whether the conduct is fair or unfair, which means necessarily that there must be two sides of the story. It cannot be decided in the abstract whether waving the flag is unfair discrimination without hearing from the flag waver and why in that particular instance it isn't unfair discrimination. And that's what the Act sets out. In other words, is this inquiry with both sides being able to tell their case given the particular facts. So it cannot be described in the abstract that all such displays are going to be unfair discrimination. So what precedent would be set by banning the 1928 flag? So it would render all such displays as unlawful and amount to a ban. And such a ban could set off a series of unintended consequences. So first, it could drive hateful views underground where they cannot be monitored. And there's enormous value in being able to gauge the extent of racist views in South African society. When people are free to display the flag, we can determine the number of people who are interested in doing so. When that freedom is removed, it becomes much harder to assess the issue. So at the moment we know that this is an incredibly rare instance. It almost never happens that anyone waves the flag. So we know that, in other words, those that have that kind of attitude or that desire for it are in an extreme minority. But if we have a ban, we lose that information in society to be able to monitor how many people have that interest. Second, the other difficulty is that the ban may backfire. So those that had no interest in displaying the flag before the banning may display it in protest of the banning. Now, in AfriForum's affidavit, there's a cartoon by the cartoonist Germ, which has an image of one person in the middle of nowhere holding the flag, and it says before the banning. And then in the next panel it says after the banning, and there are throngs of people waving the flag in protest. In other words, those that would have had no interest whatsoever in waving the flag now wave it for a different reason, which is, a protest against censorship. And so there's this unintended consequence that may occur. And third, which I'll spend a bit more time on, is that it could create a precedent for the banning of other flags that are offensive and cause emotional distress. Now, the flags that are identified are the Union Jack, in other words, the British flag, the flags of the ANC and the South African Communist Party. Now, the Foundation in its papers makes the claim that they are not, that they are different on the basis that they're not associated with exclusivity, superiority, or hatred based on the prohibited grounds of Papuda. But the prohibited grounds include race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, and birth. And we know that millions perished under the banner of the hammer and sickle in the USSR and communist China because of their religion, beliefs, culture, age, and social origin. Now, I think it is not AfriForum's case that these flags ought to be banned. In other words, there is no counter-application to say that these flags ought to be banned. The point is to say that if we create a precedent which allows for the banning of the 1928 flag, it opens up the room for these other flags to be banned, because they also are symbolic of atrocities. And so, just to explain some of that in a little bit more detail.
Well, you don't need to go to all those examples. The point you are making is to create precedent for the banning of other flags.
Yes.
You will need to have a list of the other flags which may be banned, even if your point goes.
Well, the reason is to say, if the claim said, but the old South African flag is different, all the reasons given don't apply. One of which is that apartheid was a crime against humanity, and communism was not declared a crime against humanity. This isn't argued as a distinguishing factor.
Assuming you are right to say that it would be dangerous precedent to banning other flags.
Yes.
Need you go into what the other flags are? And will there ever be an end to that list?
There would never be an end to that list.
Should we look at the list at all?
I think what I'll do is I'll constrain myself to a smaller example. So, first of all, I think it's interesting to we think about the crimes against humanity. Apartheid is listed as a crime against humanity. And as my learned friend for the minister mentions, it is one of 8. One of the other crimes against humanity is murder against the civilian population. And we know, for example, that the South African Communist Party flag, in those countries, that civilians were murdered in an atrocious manner. So, on atrocities committed by Mao, the historian Frank Dakota says the following: the death toll stands at a minimum of 45 million excess deaths. Coercion, terror, and systematic violence were the foundations of the Great Leap Forward, thanks to the meticulous reports compiled by the party itself. We can infer that between 1958 and 1962, by a rough approximation, 6 to 8% of the victims were tortured to death or summarily killed, amounting to at least 2.5 million people. Torture is, of course, explicitly mentioned in the crime against humanity. Other victims were deliberately deprived of food and starved to death. Many more vanished because they were too old, weak or sick to work, and hence unable to earn their keep. People were selectively killed because they were rich, because they dragged their feet, because they spoke out, or simply because they were not liked, for whatever reason, by the man who wielded the ladle in the canteen. He estimates that at least 3 million died of starvation and disease in gulags, labor and education camps set up by local governments. Over 8 to 9 million detained in such camps during the Great Leap Forward. Between 1 and 3 million committed suicide. What we have, in other words, is the symbol of this pernicious regime that killed 45 million people in China being the hammer and the sickle. It is the very symbol used by the South African Communist Party. Now, there are survivors living in South Africa of the crimes committed by communist regimes, people who fled. A lot of people left Russia to come to South Africa and witness these atrocities firsthand. Imagine coming to a country and seeing people celebrate this symbol that presided over the deaths of 100 million people in total, some of your own family members, and feeling this immense sense of hurt of this offense. In other words, that must be an awful, uncomfortable experience. Now, if the thresholds are lowered in Papuda to say that hurtful symbols are going to count as hate speech, well, that person has a very good case to say the South African Communist Party flag ought to be banned. They can say the crimes committed were crimes against humanity. They were crimes against people that I knew, that I loved, and against many other people around the world. This flag hurts me, and on that basis ought to be banned. Now, AfriForum's claim is not that it ought to be banned. The point is that people express different views in a society that you tolerate. That you can say, I think waving that flag is despicable and repulsive and offensive, and I will fight to the death for your right to do it, because that's what it's like to live in a modern democracy. We respect these differences. Now, with regards to the claim made by Josie Pride about the homophobic nature of the old South African flag, it is true that the old South African government had anti-gay laws, and they are repugnant and repulsive and ought to be rejected. And our new South African government did exactly that. That we were the 5th country in the world to celebrate gay marriage. And what we currently have is 74 countries around the world that have criminal sanctions for homosexual conduct. And there's a list of all of their flags in the papers. And if the test is to say that, well, if a country has homophobic laws, and the punishments for them are severe, they're much worse than it was done in South Africa. Whippings, imprisonment. Yes. Yes. And in other words, to say that when people wave those flags, it could very well signal to the gay community, this is a disdain for you. This is, I can imagine it being very hurtful. In other words, if you know that in Iran people are thrown off buildings because they're gay.
I'm quite sure what are you saying.
The claim is this.
What are you saying to the Johannesburg Pride? I thought in your papers you seem to be saying you are understanding their code.
Yes. Well, in other words, the claim is as follows, which is that it is important that a principle is entrenched in our law which allows people to wave flags, and that the gay pride flag is an immensely important flag in South Africa and ought to be protected. And there is a danger that if the old South African flag is banned, it would create a precedent which could lead to the banning of their flag. Now, we know in their papers they cite an example in Egypt where people are arrested for waving the rainbow pride flag. In other words, this is a community that has been subject to vilification around the world, continues to be, was so in South Africa, that we happen to live in a wonderful moment at the moment where gay people are given protections, that pride rallies are attended by, people of all walks of life. But this is the moment we find ourselves in now. Lest we forget that when the first gay pride rallies were held in South Africa,
but they're saying, because you are hurt, you didn't go to that part. They say, we have comfort in the current situation. And I'm not quite sure what they're saying against that argument by calling a lot of other states which are backward and where the situation of LGBTI is the worse.
Well,
They're saying by just waving the flag, which reminds us of what the law used to do here, the experience they have now.
yes,
And you say, yes, I understand.
yes.
That was the position there. But what is the use of referring to 74 other countries where the situation is different?
Well, it's simply to say this, that if the principle which is being used is that a flag ought to be banned if it was the flag that presided over homophobic laws, okay, which is the case made by Josie Pride. In other words, the old South African state had homophobic laws, and the flag that flew at the time was the 1928 flag. And on that basis, they say that flag should be banned because it causes ongoing hurt to the gay community. The point is to say, well, let's take that principle and let's apply it consistently and accept that 74 countries around the world currently have awful homophobic laws. And that if the principle is merely that a flag which is associated with a homophobic state or homophobic laws can be banned on the grounds that it is hate speech, well, then we have truly opened up the floodgates.
Well, I can tell you to tell them, but it means there are 74 or 36
In Africa.
states whose flag you have discomfort with. What is actually an answer? To say to them, this is not the only one that you should discomfort with. There are others.
No, it's to recognize that, in other words, discomfort can be broad. That pain, that sense of hurt is legitimate. I can imagine that a gay person seeing an Iranian flag would legitimately feel hurt and feel.
The point I'm really making is why are you even bringing that flag in the context of this case?
It is merely to point out this, which is that.
Not insensitivity towards that.
No, not at all. In other words, it is to recognize.
I think that you can take the point up to where you want it.
Yes, it's to recognize the pain. At no point is there a denial of the pain. I understand that it would be, as a gay person, painful to see an old South African flag, to say that that was a regime which had homophobic laws and marginalized me. I understand that, I acknowledge that. The question is, well, does that make it hate speech that must be prohibited and require a banning of the old South African flag, the 1928 flag?
That point you've made.
Yes, and the point is to say that if we use your principle for banning, well, it has this much broader effect, and that is the slippery slope danger. In other words, it's not a simple matter for a court to say, well, I'm going to ban this flag. It must do so on the basis of principle. And that principle must be cashed out, and the question is, well, does it lead to a bunch of unintended consequences which are deeply counterintuitive. I would think that the banning of 74 national flags, or the potential for them to be banned, is deeply counterintuitive. In other words, there is nothing stopping someone else from saying, well, if the threshold is so low that all we need is the sense of hurt for a national flag, well, the floodgates open. And so that is the difficulty. And so that's why those flags are mentioned. They're not all identical with each other, they're not all the same. The point is, once the principle is established, it allows for this slippery slope to occur, for these other flags to be identified and to be banned. That is the purpose of it. So finally, the question is, can displays of the 928 flag be curbed without recourse to the law? So there are a range of activities that many would understand to be immoral or offensive without thinking that they ought to be illegal. It may be improper to swear, have an adulterous relationship, drink to excess, utter blasphemies, watch pornography, display poor table manners, or tell an off-color joke. These odious activities are best combated by social sanctions and expressions of moral disdain. It would reek of totalitarianism to use the law to punish these behaviors. Now, some of these behaviors were punished by law in the past. Many countries had blasphemy laws or punished adultery, and then felt that that was best dealt with by society, not by the law. The Human Rights Commission itself said the following: the strong condemnation and public shaming attendant on these forms of speech ensures that we do not resort to a knee-jerk response of demanding that free expression be curtailed, but rather we encourage a constructive debate around these issues and allow the values of our constitutional democracy to shine through. We can express our confidence in our growing constitutional democracy and trust that society's moral outrage will be correctly placed, as was evident in the public debates around all of these complaints before the Human Rights Commission. The Commission may set the tone of these debates by issuing press statements condemning them and placing them firmly within the context of inappropriate speech for a democratic society. Ultimately, the best remedy for offensive speech is counter-dialogue. When people make racist statements or use offensive symbols, an opportunity is created for public discussion. When people wave the 1928 flag, it's an opportunity to engage them and persuade them of the error of their ways. This approach will discourage displays of the flag without using the strong arm of the law. And it's exactly what AfriForum does. In other words, they tell their members, don't use this flag, it's insensitive. And that can be dealt with without having to send in the police force, without having the law play a role. In other words, we're perfectly capable of regulating our behavior and immoral behavior or improper behavior without recourse to the law. In other words, there are better and more socially appropriate ways of expressing disdain for ideas or images or words that we don't like. So I'm going to conclude by just pointing out what the summary of our matter is. Firstly, this court does not have the power to declare future displays of the flag as hate speech, unfair discrimination or harassment, since Maputo only empowers an equality court to make orders relating to hate speech, unfair discrimination or harassment that have already taken place. Second, the court does not have the power to declare Section 10 of Maputo unconstitutional, since its powers are limited to those contained in the Act. Third, the case could never be ripe for hearing because it relates to abstract, academic, hypothetical and prospective conduct, as the applicants described it, a dispute of law between the parties. Fourth, Maputo does not regulate displays of the flag, since the flag cannot be reasonably interpreted to be a word. It's not unconstitutional for only regulating words. International law does not change the position. If Maputo did regulate displays of the flag, not all of the displays the Foundation seeks to declare as hate speech, discrimination and harassment would qualify. Each display would have to be judged on its own merits. Seventh, distasteful displays of the flag can be discouraged through expressions of moral disdain and social opprobrium. I have no further submissions, Lord.
My Lord, I'll be a couple of hours. My Lord, I'll be about 20 minutes, but perhaps it might be better to do it tomorrow morning.
Say if you want to argue until tomorrow morning, I'm available.
I mean, ready to do it. Thank you.
So what was it?
Tomorrow morning, and then I think the replies, and that will be the
No, I don't want them tomorrow morning. I said to you, we didn't get this argument. isn't it better if we have 20 minutes of argument that they can sleep with their argument and reply as quickly as possible tomorrow morning?
I leave it to my learned friends if they want that advantage.
I know. My suggestion will take us outside of court power. Let me be more comprehensive to hear what I do.
I tried to expedite matters, but I failed. I suspect there's no advantage to be gained unless my learned friend intends going outside his heads of argument. But if he needs the evening, I'm not going to stand in the way.
I believe we have to adjourn. We will adjourn. But I'm just I was glad to say I said to the having nobody survived to sit outside we want to adjourn.
It appears so, my lord. Thank you, and I would appreciate the indulgence. Thank you. Yes, certainly. Thank you.
How do you know if you guys are going to pass?
I know of only of myself. I suspect Mr. Trengov as well as a second applicant.
I want to remind you that you're not alone.
I would like to reply, but I'll be very brief. I think 10 minutes maybe.
Well, the days are available tomorrow. It's going to take a sense. So tomorrow we will be taking second amicus argument before we go to the trial. The courts are adjourned.
Rise.
There's so much time for it. Otherwise, you're trying to split this thing.
I'll try and think of some more.
Oh, thank you.